Okay. Okay, we are ready. So welcome to our final panel of the day, although we still have a plenary session afterwards. We have three distinguished panelists. One is our paper author, Enrique Armejo, who is a professor at Ilan University School of Law, a faculty affiliate at the Yale Law School Information Society Project and the UNC Chapel Hill Center for Information Technology and Public Life, and a research fellow at GWU's Institute for Data, Democracy, and Politics, and he also teaches at Wake Forest. You may win the award today for the most affiliations of anybody. That's great. And
Hopefully they all add up to something at some point.
He teaches torts, freedom of speech, constitutional law, and administrative law. And in addition, one more affiliation, in addition to this paper, he's also working on a Knight Foundation-funded research project on disinformation, knowing lies, and the First Amendment. His paper today, as you can see on the board, is Section 230 as a Civil Rights Statute. To his left is Kate Ruin. She is the Cy Sims Director of the U.S. Free Expression Programs at Pan America. She's an attorney with a strong background in legal research and is committed to freedom of speech and to bringing focus to the ways in which a strong commitment to freedom of expression benefits communities of color, religious minorities, LGBT communities, and other marginalized groups. So perfect for the theme of our program here. Most recently, Kate led U.S. policy at the Wikimedia Foundation, and prior to joining Wikimedia, she was a senior advisor for the First Amendment and consumer privacy at the ACLU. Finally, to her left, we have Eugene Volokh, who is entering his 30th and final year, at least as far as we know, as a professor at the UCLA School of Law, where he has taught First Amendment law and a First Amendment brief clinic. He's, of course, written extensively on First Amendment law, considered one of the leading, if not the leading, First Amendment scholar of our time. Very importantly, because I'm one of the bloggers, he also has an eponymous legal blog known as the Volokh Conspiracy that some of you may have seen, which has been the leading law professor's blog for over 20 years. And starting in July 2024, Eugene will be a senior fellow at the Hoover Institution at Stanford. And with that, let me turn things over to Enrique.
Well, thank you. Thanks to VFL for supporting this work and for putting together this panel. It's just so great to have the perspective of someone like Kate, who has been working so directly on these issues for so long. And it's great for me personally to be sitting up here with Eugene and David. I have been reading their ideas and been influenced by them since I was a law student. And as you can tell from the color of this beard, that's a very long time. So the paper, let me just make sure I'm in the right place. We're going to talk about Section 230 generally today. I think everybody understands that the way that it's going to operate in this context is as a bar on distributor liability for the speech of another person. And by other people, we're referring here mostly to users of social media. And one way to kind of demonstrate the mechanics of how Section 230 is speech protective, in the particular civil rights context, is to go through some examples that demonstrate the concept of collateral censorship. So let me just go through these so you can get a better sense of what the paper talks about. And this was really my goal with this project. It's often asserted that Section 230 is speech enabling, especially with respect to underrepresented people, underrepresented point of views. But my goal here was to try to actually demonstrate how it actually works in this regard. So the first example I'll talk about with respect to civil rights-related speech is the live streaming or the posting of an act of police brutality, right? So you have a user of social media who takes video of that act and then posts it to social media, which is the distributor of that speech. And then assume there was someone in power, in a position of power, who doesn't like that speech was distributed and wants to take it down. And the first option for that person is a threat to the user, right? What we would consider to be the speaker rather than the distributor. And the possible legal basis underlying those threats the possible legal bases are many. Tim this morning talked about public order laws, many of which were passed after the demonstrations in 2002. So criminalization of approaching a police officer from a certain distance, releasing information about an officer in the course of their duties, releasing photographs of an officer without the officer's consent. People recording in public have been arrested under state wiretap statutes. Or you could even imagine the example of a state that has criminalized abortion and has also criminalized the distribution of information about how to get one. So the person with legal authority can threaten the speaker directly, or they can threaten the distributor of that speech. And that's the issue of collateral censorship that I say the statute is intended to address. Now, it is true, absolutely true, that there are legal defenses that the user can assert on their behalf, that the distributor can assert on the user's behalf or on its own behalf. If you pick up your Know Your Rights card as you go out the door, you'll see that there is increasingly the federal courts have found a constitutional right to record and post police activity. These platforms often can and do fight unmasking requests, especially when anonymity is part of their business model. Platforms often have a business interest in being seen as protective of user rights because, of course, then they'll get more users. But the incentives to assert the substantive defenses, I think, are quite minimized when the more rational thing to do is for the distributor to just cease distribution to try to make the threat of immunity go away. But because of the current liability regime that the statute provides, the collateral threat's not effective, right? So the result of that is no collateral threat. And the result of the ineffectiveness of the collateral threat is more speech about police brutality. So another example, and this one we know about as well, Me Too. So you have users of social media, mostly but not exclusively women, posting about sexual harassment and assault that they claim to have suffered at the hands of powerful people, mostly but not exclusively men. Again, assume a powerful person who wants that speech taken down. They can, and the powerful person can and often does, threaten the user with legal liability in the form of defamation threats. That's the direct censorship claim, what we would call, but can also make the threat in the absence of immunity to the distributor of the speech. Again, both the user and the distributor have substantive defenses, right? If the person making the threat is well known, as they often are and were, they'll have to show actual malice, not just on the part of the user, but also on the part of the distributor for purposes of their defamation claim. But again, the platform doesn't have any incentives to assert the substantive defenses if there's even a 1% chance that there's a basis that there's real legal liability. So what the distributor is going to do in the absence of immunity is take the speech down. Again, because of the immunity provided by the distributor, the collateral censorship threat fails. So why is collateral censorship so bad? Why was Congress so worried about collateral censorship when they decided to pass Section 230? Because over-moderation is inherent in people who are trying to avoid legal risk, right? And the over-moderation is in response to these threats. It's not just with respect to the speech that's a subject of the threat. It could also be potentially speech that's like the speech that's subject to the threat, which again is going to result in much less speech about topics that maybe are deserving of protection. There's no economic value in one police brutality video stream. This is speech on the fringes, right? This is speech that in many cases is most difficult for the platforms to monetize. That's why Section 230, in my view, is particularly so effective with respect to protecting civil rights speech. So I know we're going to talk about the counter-arguments to Section 230 in the Q&A, but let me just kind of put those out there on the table so we can talk about them in more detail. So the first, what I would call the direct anti-230 case, is that Section 230 actually leads to less speech about civil rights, right? So here you have someone who's using a platform to talk about an issue, and then, as we all know, some of us know, unfortunately through personal experience, there are other people online who don't want that speech spoken. So we'll call this actor the harasser, right? Well, the harasser uses the same distributor to harass the speaker as the speaker uses to speak, right? And many have argued that the effective way to deal with harassment online would be to permit a collateral censorship threat from the user against the platform with respect to the harassment, right? But the problem is that Section 230 immunizes that threat as well, right? You can't be, the platform, the distributor can't be held liable for the distribution of the harassment. The immunity applies there. That disincentivizes the platform to do anything about the harassing speech as well. And the argument goes, the effect of that is that that speaker leaves, right? They have to weigh what's the benefit of being able to say what I want to say versus what's the cost of this harassment, and that speaker winds up leaving. The second anti-230 case, I would say, is kind of more of a collateral attack on Section 230, and that is based on the premise that distributors discriminate as well, right? So let's say we have anti-vaccine speech that the distributor decides it doesn't like. Maybe, as we've seen recently, the government might not like that speech, so the government is talking to the distributor about how maybe that speech would come down. And then the distributor decides to not distribute that speech, right? And this is a problem too, and it's such a problem that, as I'm sure you know, 2 states have decided to do something about it. So Texas and Florida come along, pass substantially similar laws to try to rebut the ability of the distributor to discriminate against speech it doesn't like. So what do? They essentially pass laws that say that the distributor is not allowed to discriminate with respect to the speech it carries. So that's the basic gist of the paper, and I look forward to the comments and the questions from the audience.
Thank you. Kate?
Sure, thanks so much. Can everyone hear me with the mask? Great, okay, thank you. So, again, thank you so much for having me here. This is an honor. I really appreciate having been invited. I also appreciate that Enrique kept his paper to 30 pages. But I am probably about to suggest he had 30 more, because in my job, I'm not an academic, and I'm not a litigator. What I do is I run around talking to policymakers about why free expression matters. And I spend a lot of time, there is no law closer to my heart than this one. And the arguments, the fundamental arguments this paper makes, and this paper provides evidence for, are things that I've been saying for years. And so be sure that as soon as I am able to do this, I will be providing this to every single person who will read it and listen. Because I fundamentally agree with and have been intuitively making these arguments for a long time. And so in engaging with the paper, I've thought about these issues for a very long time. I agree very much with it. I think that it would benefit from disaggregating who the distributors are to a certain degree. I think, a lot of times we talk about platforms, but Section 230 actually applies to far more than platforms. And by platforms, I mean like Facebook, Google, edge service providers. We're talking about more than that. We're even talking about more than just Facebook and Google and Wikimedia, where I used to work, and Glassdoor, which the article mentions. We're talking about more than just places like that. We are also talking about Cloudflare. We are talking about MasterCard, which is making more and more content-based decisions over who gets to use its payment platform, PayPal and Venmo, also discriminate on the basis of content, also avail themselves of 230, and also claim certain issues about 230 as reasons for some of the censorship in which they engage. So a little bit of disaggregation on that, even if it's just to say, when we say platforms, we're talking about this group of platforms that benefit from 230 and not these, I think would be really helpful in clarifying. In terms of the arguments it makes about Section 230 being supportive of civil rights and civil rights speech, the 3 examples that are listed are good. I think that the absence of a fuller treatment of abortion speech, abortion-related speech, is a missed opportunity, because in real time, we are seeing how Section 230 is permitting speech related to abortion, related to reproductive care, to remain online in places where it is now arguably illegal. This is incredibly important, and we're seeing it unfold in real time to the extent that we can start pointing to those efforts where state attorneys general are trying to threaten platforms, trying to force them into censoring that sort of speech and failing because of Section 230. An incredibly important thing, I think to draw out. I have notes. The other thing that I think that this paper could really benefit from talking about a bit more, or actually at all, is, Section 230 has existed since 1996. It's been amended exactly once, and that time was with a law called FOSTA. SESTA FOSTA, but FOSTA was the part of it that amended Section 230 to open up liability for state and federal criminal and civil laws related to sex trafficking. To me, that was one of the largest civil rights failures of the past 20 years. And we have documented evidence. There are law review articles out there. There are studies out there indicating that FOSTA caused platforms to engage in the exact kind of over-moderation and over-censorship that Enrique's article argues will happen should we amend 230 again, in ways that carve it out to create larger liability risk for certain categories of speech. So not only is it evidence that supports the legal arguments that Enrique makes, it's also a civil rights harm because it was aimed at speech that is in service of, ostensibly in many places, a crime, whether you agree with it being a crime or not. I don't, but many do. It was aimed at speech that is ostensibly in service of a crime or in service of harming children. And instead it wound up encompassing all kinds of speech related to sex. And that would include anything related to LGBTQ speech, sex education, lots and lots of sex worker content that was perfectly legal came down. Many sex workers have intersectional identities. They are people of color. They are often LGBTQ. Many are trans. And their content, their livelihoods, and their safety was interrupted by this by this law. And that, to me, is, in fact, a civil rights harm on multiple levels, and worth exploring in this paper. Other things. As you can tell, I really loved this. So a couple paragraphs talking about FOSTA I think would be really helpful and really strengthening of the argument. The other thing I noticed is, when we talk about Section 230 as a civil rights statute, the examples that are listed already are extremely useful and well explained. But I also think that we're missing a fuller treatment of some of the harms that civil rights advocates are really mostly raising the alarm about. I think we should dig into those issues further, as that will be how we really open a dialogue with civil rights experts about how Section 230 is supportive of their work rather than mostly harmful to it. The paper really does dig into the harassment angle of this, where the argument being made by many scholars, including Danielle Citron and Marianne Franks, whom I read every chance I get, because I think it's important. I disagree with them often, but they engage thoughtfully, and we definitely agree on the conceptualization of the problem, where the idea is that people with marginalized identities experience more harassment online and are therefore driven off of platforms being edge providers in this circumstance. And if we would just amend Section 230, that would incentivize additional good moderation, getting rid of some of this hate speech and permitting more diversity of ideas to be lifted up on platforms. It's a really intuitive argument. And I think that, to the extent that the response here is, well, actually, harassers are generally more powerful than those they harass, and therefore platforms will be more responsive to the harassers than the harassed should we amend Section 230 to permit more takedowns of harassing content. I think that's possibly true to some degree. I'm not sure whether it would convince the legal scholars who are making these arguments. I'm curious as to what would. A real engagement with them would be helpful. And I know that they engage in other spaces. But I also just want to push back on the idea that the harassers are always people in greater positions of power. I think that there are very powerful people who have been driven off platforms by actors who are far less powerful, but have found power in their ability to understand and use platforms tools to truly swarm and harass more powerful people out of places of public engagement. And I'm thinking specifically of the case of Taylor Dumpson, for example. This person, she was the first Black student body president at American University, and Andrew Anglin, noted white supremacist, decided to target her, and he sent his army of unpowerful nobodies after her, to the point that it spilled into her online life, into her offline life. People were posting signs telling her, threatening her in her dorm. Just so much harassment came at her that she eventually filed a civil rights lawsuit for interference with her ability to obtain her education, and interference with her right to access a place of public accommodation against Andrew Anglin and his mob. And she won. And so we have to think about things like that too, how the collective, how people with personal, in and of themselves, a lack of power, when they band together, can create a fair amount of civil rights harms themselves. And are there mechanisms outside of changing 230? Because this lawsuit happened with 230 in place. Are there mechanisms outside of changing 230 that we can look to that support civil rights as we're thinking about Section 230 itself as a civil rights statute? The other categories of speech that I thought of that I hear my civil rights colleagues talk about a lot when they talk about 230 are voting rights and voter suppression and disinformation. It is well documented that there are disinformation campaigns that exist entirely to create doubt amongst marginalized communities regarding candidates for office, regarding time, place, and manner of voting, qualifications to vote. It is well documented that there is a fair amount of voter suppression that goes on online. I think we need to talk about this, and that changes to Section 230 that would change distributor liability would probably disincentivize the good speech related to those issues as well, and probably more than we would want it to. And then the last thing I'll say, since I've talked too long, obviously, is that the other thing that I want to think about when we think about this article is the ways in which Section 230 is actually occasionally being weaponized by platforms against actual civil rights laws. So to the degree to which they offer Section 230 as a shield against lawsuits that they should probably be liable for and have been found to be liable for. So I'm thinking of Fair Housing Act violations when platforms make decisions about who audiences for certain opportunities, housing, employment, credit opportunities, can be on the basis of protected class status. And there are other circumstances as well where platforms are making decisions that are discriminatory, and they try to claim that Section 230 protects them from liability for civil rights law violations, we need to think about that too when we call Section 230 a civil rights statute. I don't think that Section 230 protects that behavior, but all possible amendments to Section 230 aren't created equal. Some are clearly very bad. Maybe there are some that would clarify that particular aspect of it, and I have seen some. I have seen some proposals in Congress that get close. Okay, that's it. Thank you so much. Thank you for writing this.
Thank you, Kate. Eugene?
Yeah, so I also think this is a very important paper. I generally like it very much. I have a bunch of fairly specific suggestions, but on balance, I think this will be something that much advances the debate. Some of my suggestions very much agree with Kate. So first of all, I do think a separate section on abortion-related speech is quite important. And I will tell you, there is some abortion-related speech that would be a crime under the laws of many states that ban abortion. For example, outright kind of saying not just, oh, you should get abortions even if you're in a state that prohibits it, but here is the place you can go to right across the border to get an abortion, or even, actually that's a little bit less clear because maybe they can't criminalize that, but here are the places where you can where they will diagnose you in a way that suggests that this is a real threat to your health and you'll be able to get an abortion. That may very well be punishable solicitation. And, maybe, not that I support the anti-abortion laws, but in a state where there are such laws, it may be the person is punishable, but you don't want to be in a position where the platform has to do the policing. So I think that's an excellent example. I haven't thought much about the Sesta Fasta things. I don't know the exact details of what's been done, and but it sounds from what Kate is saying like that too could be a very helpful section. I think each such section is extra powerful ammunition. As to the existing sections, I think you want to prune down some of your examples with regard to videos. It's a mix. Some of them are indeed situations where the platform could say, look, we are worried about liability even at the 1% level. Others, like you give an example of Arizona law that bans people from video recording police officers within 8 feet or something. Maybe I got the radius wrong. I just don't think that that's really going to be in play. So you just want to you've got lots of great examples. Don't dilute them with things that are more tangential. I think there is a tension between your claims that platforms would underprotect users absent Section 230. That is to say that they'll just say, look, when in doubt, take it down. And their willingness, as you point out in the anonymity section, to go to bat for the users as to unmasking subpoenas. I think both can be true, that they do go to bat in some measure in some situations, especially when they're not faced huge liability, although it costs them money in lawyers' fees. But you want to talk about that, I think. You cite various articles that talk about over-moderation and over-representation of minority groups. It may be true. Certainly there used to be this talk about under-representation of minority groups online, the digital divide and such, which I think was probably overstated. But maybe those statements are today correct. But I always worry when it's like you cite a Brennan Center report. I think Brennan Center people are wonderful people, and I would say the same thing if you cite a Heritage Foundation report. But they're going to have their own perspectives. They are going to have their own risks of error because they're human. There's going to be an extra risk of broken telephone where they report something in a particular with some subtle change which makes sense in context because you can't summarize complicated data in a perfect way. But then when you summarize that imperfect summary, there's always this risk. I would be more confident if you were to cite the underlying studies. Of course, give credit where credit is due to the places where you got them from. But cite them and maybe even give some specific numbers and specific examples. I am in particular influenced by the sense that this is very hard stuff to actually measure. Over-representation or over-moderation. It's just, you have very limited subsets of the data. So it may be that there's this big story that's told on the basis of one or two very limited studies. Maybe not, again, I don't know. But that's what worries me whenever I see citations to intermediate positions. You mentioned in passing the frequency of false claims of sexual assault, also a very difficult question. There are some complications with this. One is that the studies, if you actually look at them, say these are the situations where the police department has said, we think this person is lying. And then there's a situation where the police department says, we're quite confident this person is telling the truth, and we're going to ask the prosecutor to prosecute. And then there's also a substantial group of people in the middle where they say, you know, we're not saying that the accuser is lying, but we're not sure. There's not enough evidence probably for court. It's not enough evidence for us to make up our minds as well. So the actual rate of false accusations may be higher. It may be lower. No, it's very hard to know because you don't have a basis for knowing for sure which accusations are true or false. But on top of that, that has to do with police reports. You could certainly imagine somebody who would be reluctant to lie to the police, which is actually a crime, but just fine sending off a tweet. You can imagine the other way around because you say, send off a tweet, everybody hears about it, maybe I'll get sued for libel, maybe. But that's something that's worth mentioning. Incidentally, 2 days ago, the Minnesota Supreme Court had a 4-3 case on the question of whether accusations of sexual assault are on matters of public concern. And there was a debate about this very factual question. Okay, 3 other things. One is, you mentioned the Texas and Florida laws, and you just sort of say, well, they're preempted by 230C2 and by the First Amendment. I think it would help if you talk briefly about the counter-arguments, whether to explain why you think they're wrong or just to say they're there, but here on balance for reasons given in this place. You see that. Obviously, the circuits have split on the First Amendment issue. The 230C2 question also in lower courts, some courts say that provides categorical protection for platforms. Others say under eius dem generis it only provides protection for certain kinds of things. It would be worth doing. Second thing which ties to what Kate suggested is some of the suggestions aren't to repeal Section 230, but have narrow exceptions. So for example, you talk about the Citron Frank's proposal to ban harassment-based threats. And you say, well, this will, I think you actually put it in kind of flip it around inadvertently, what they're saying. But it sounds to me like you're saying, look, they're saying ban harassment-based threats because such a ban would protect those who are most likely to suffer harassment. But you say, well, it'll also protect speech about the powerful. Well, the powerful shouldn't be threatened either. So what about a ban on outright threats? Excuse me, not a ban, an exception for outright threats. That if something is a threat of violence, that the platforms should take it down. Now, I can see the counter-argument. I can make the counter-argument. It just, I think you need to talk about that. By the way, if you do talk about that, it's also really important, I think, whenever you use the word harassment, that you explain what you mean. Harassment is a word with many different meanings in different contexts. All of them are quite vague, and that's just legal context. So, for example, some of what I hear about when they say harassment, it's everybody saying insulting things about the person. Well, that's actually constitutionally protected. And sometimes harassment in some states, harassment is actually a crime defined as threats. And, that's unprotected. Relatedly, it may be worth mentioning, I didn't see it talked about in your paper, is revenge porn. So I think there's a perfectly plausible argument for an exception for revenge porn. It would be presumably limited to, like, if there is a risk of error, its risk of error would be as to porn. Now, you might say even that's a very serious problem, but maybe not. One problem, of course, is how will the platforms tell, even with a complaint, whether it's revenge porn? Like, how do they know that this is something that depicts the challenger or the complainer and such? At the same time, revenge porn laws aren't really going to work if the platforms aren't on the hook, because a lot of this can be posted anonymously or from overseas. Let me mention the last thing, and this ties in. It's not exactly what Kate was saying, although it's in the same area of anti-discrimination law. The most obvious way in which Section 230 undermines civil rights is it preempts civil rights laws. It doesn't preempt bans on housing discrimination and advertising discrimination as applied to platforms that themselves do that discrimination because they pick and choose. Right. But roommates.com, which of course has this complication of the right of intimate association, but you can set that aside if it isn't roommates.com but rentals.com, would be allowed to have people post things, so long as it doesn't guide them towards that says, we will only rent whites, or we will not rent fundamentalist Christians, let's say. Or more benignly, I'm looking for somebody who shares my house who also is an Orthodox Jew because we need to keep kosher together, or something like that. There's roommates.com. There's also Seeks for Justice, where the claim was, I think Facebook was removing certain kinds of material. And I think there's also was a claim by some Falun Gong people who said that some place was removing things that supported their views at the behest of the Chinese government. It may be unbalanced that, it's good to leave the cause of action only against the actual poster. But I think that is a counter-argument you need to talk about, or you ought to talk about. So that's that. I will actually send you an email with there's this bulleted list right now. So you didn't need to take notes.
All right, so I have a question as the moderator here. Having participated in social media as a blogger, as a commentator, as a consumer of reading things for many years now, it does strike me that, 95, 98% of the problem is anonymity. That people say and do and threaten and harass and insult in ways that they would not only never do in person, they would never do if their name was attached to it, they had to live with the consequences. And frankly, while anonymous speech, certainly you don't want to ban it, it strikes me that because anonymous speech is so, really, nothing makes a comment section or a thread go off, get off track more than people start throwing anonymous comments. So anyway, my question would be, what if the rule was that if you have identification verification on your site, you are immune as you are now, but we're not banning anonymous speech, but if you allow anonymous speech, you have to moderate it, and if you don't, you're liable for the consequences.
That sounds like a civil rights harm to me. I hear that, but I also am keenly attuned to the fact that many difficult accusations or disclosures are made first anonymously. A lot of lawsuits filed are done pseudonymously or under seal because people are especially when they're making disclosures or accusations against people much more powerful than they are. Harvey Weinstein stayed protected for 50 years because people were afraid. It's not because he wasn't doing it. It's not because people didn't know. It's because people felt unprotected in making disclosures. And I think that, the Me Too example is a really good reason to say that, it has to be okay for platforms to choose to allow anonymous speech and for them to maintain their liability protections if they do make that choice. Enrique raises the example of Glassdoor, which permits anonymous comments about employers for good reason. And they protect that anonymity because you aren't going to get many of the disclosures, many of the candid assessments of what it is to work in a place when you are afraid of a defamation lawsuit, even if it would be a SLAPP suit. So I kind of think that we really do need to maintain and recall the value of anonymity, not just as a high-minded thing, but as a practical protection for people that have either experienced injustice or want to talk about injustice that they have seen, but need to do so in a way that protects themselves because people also want to continue to live their lives.
So my position on online anonymity, I would say, has evolved. I think when I first started thinking about this, I thought the Scalia position in the dissent in McIntyre versus Ohio was very defensible. I think there's a sentence somewhere published with my name on it that says something to the effect of, for every Margaret McIntyre, there are 1,000 trolls. And I was definitely of the view that if you had not even a law, but some rule or convention that said if people are less awful when they put their names to what they say. But where I am now is I agree with Kate that if the anonymity, that forcing people out of anonymity actually would have, and Eugene's going to attack this as unempirical, so I'm already prepared for that.
No.
But that the argument is that anonymity most helps people who are underrepresented, who are speaking minority points of view, and unmasking efforts with respect to that in order to try to make people more civil or whatever would have, as Kate says, would have a disparate effect on those folks as well.
So the problem is that anonymity helps two classes of people. It helps people often who are varying degree of powerlessness, who are afraid of being attacked by the powerful, and it helps people who want to ruin other people's lives, right? So it's true, it helps victims of injustice, it helps perpetrators of injustice. And that's the problem, in a sense, the printing press is similar, the internet is similar. So I'm not a foe, generally speaking, of anonymity, but I do think we want to avoid kind of over-glamorizing anonymity by focusing on the people who are helped without thinking about the people who are hurt. I will say, just as a blogger who wasn't interested in preventing litigation or preventing libel, but just wanted to keep more polite conversations, around 2005 when we were starting comments on our blog, I mentioned, I think I posted something saying, I'm thinking about requiring people to identify themselves. And somebody said, well, if you do, I will never post anything about same-sex marriage, about affirmative action, about abortion, because I'm afraid I'm going to be blacklisted. And I thought, and that was actually, I found that to be a very important point. And since then, we do allow pseudonymous comments on our blog, and my sense is probably a good 90% of people don't use their actual name. It's an interesting question whether you could compromise in some measure. So that was, I took David's point to be that. And by the way, I'm sorry, this is true both about people who might want to express politically unpopular opinions, but also somebody could say, I'd never criticize the Scientologists, right? But to give an example of a group that perhaps ought to be criticized, but at least ought to be discussed, but is famously litigious. So David's point was, well, maybe not ban it, but exclude it from Section 230 protection. You could imagine tweaks, right? You could imagine something that says, we don't exclude it from Section 230 protection categorically, but if there is a libel lawsuit, let's say brought by an individual, to set aside the Glassdoor and Yelp phenomenon where you really do want consumers to be able to say, this business is bad. And often that's in a context where people look at it and say, okay, 2 people said this business is awful, 10 people said it's good, that's fine. But if it's about a person, if it says Kate Roane was sexually harassing me, and who knows who it is who said it, then that might be something that ought to be excluded. I'm not sure. I think on balance, it may very well be that the chilling effect on valuable speech is sufficient. At the same time, while I sympathize with people who say the only way I can complain, even about particular crimes by particular individuals, is to do so anonymously. And I want to do it publicly. It's not like I just give an anonymous tip to the police, but the only way I can do it is by broadcasting that. I also sympathize with the people who say, wait a minute, now everybody thinks, just based on these few allegations, at the very least I've been accused of this. I can't find a job. I can't. My customers just say, why should I go to somebody who's been accused of this, even if there's no proof? And I can't track down this person. I can't get this removed. It's the first thing that comes up in my Google search results. I mean, I do think that's something we should think about. But I would make sure that any such exception, if there should be one, and I'm not sure, there should be any such 230 exception, should be limited to, again, specific situation of defamation lawsuits brought by individuals, maybe brought by non-government official individuals and the like.
All right, with that, we have about 10 minutes for some questions. I see Ruben has a question in the back, in the center, for help you locate him.
isn't there today a considerable scope for flexibility around, with digital technology, in particular the way you can identify types of posts, right?
I'm sorry, I'm having a hard time hearing you.
Okay. Is there a considerable way of having flexibility in this space with modern technology? And particularly, you can determine between all these different types of posts. So you wouldn't have to go as far as saying, look, you moderate everything, right? It could just be certain types of risky posts. For example, it has someone, you can detect whether something contains an allegation against a person with a considerable reliability compared to, say, an allegation against a corporation or an allegation against a small business. So there are ways you can balance between these two things that are not as hard-edged as, basically just protecting everything. So, I would say you cut the line at named people accusing so-and-so and doing such and such on an online platform, broadcasting it to hundreds of thousands of people. But you could accuse a company. For example, you could accuse a university, but not accuse an individual working at a university. Or you could accuse, Microsoft, or without accusing, say, Bill Gates of doing something. So I think that there is a room for quite a bit of nuance. I think that today with cancellation, today with the sort of things people can do, the abuse of power that Eugene mentioned, the nasty people just want to ruin your life. I mean, they shouldn't be protected. And there's so many different ways you can censor anonymous speech or manage it. I mean, I've done experiments as a co-supervisor of a PhD where we looked at different forms of constructive speech. And actually, if you moderate everything but have it anonymous, you can get some really interesting conversations going and sort of anonymous speech that's of value but wouldn't otherwise exist, including more pro-social speech, more critical criticism of organisations. So I think the line, I may put this to the panel, but maybe with today's technology, you can draw all sorts of lines about causing problems. I think that might be why this statute should be rethought.
Thank you for that. The selective revocation of immunity point is very well taken, obviously. And the current proposal is not, the current proposals that are most talked about are actually not, and both Kate and Eugene said this, are not blanket revocations, right? They're continuing to make selective revocations of the immunity in certain circumstances. And one of those proposals is revocation of preservation of immunity when the distributor has acted reasonably with respect to taking steps to minimize harassment. Well, and I've written this in other places, there are two problems with that, right? There's the definitions of what's harassment, which, as Eugene said, presents its own set of issues. And there's also the definition of reasonableness. So in other words, the largest platforms are going to set what's reasonableness, and then the bloggers are going to have a real problem showing what they can do. Now, the law of reasonableness can kind of, it's not necessarily going to compare, Facebook to my, blog with 100 or 200 readers on it, but these are the issues, again, that the immunity is kind of designed to prevent, because if you have a definition of harassment that is at all susceptible to interpretation, the interpretation, as I'm arguing in the paper, is going to cut in favor of takedown rather than leave up, investigate, and figure out the extent of the liability later.
I also want to add on to that a consideration that we sort of always have to remember when we're talking about relying on technology to do content moderation. So the question is always going to be, can you do it at scale? And the answer, when there is any nuance at all, is no. You can't accurately do it at scale. You can do it within some possibly gigantic margin of error. Maybe a small margin of error in English, bigger and bigger and bigger the further you get away from English, right? And we need to remember those sorts of things as we're saying, okay, there are these bad things out in the world, but if you can design technology that can censor at scale, then maybe we're doing better to just rely on that and create liability that forces the companies to rely on it because they have to. It's billions and billions and billions of posts, right? So we have to remember that we have to treat changes to 230 as changes to content moderation, and we have to remember that every time we change content moderation, we create these incentives. They're going to be imperfect. The solutions that the companies build will be imperfect, and the imperfections, very often, the more we study it, show us that the imperfections fall and harm marginalized speakers more. And maybe it's worth it. Maybe it's worth it sometimes. But we need to really engage with that as we're talking about some of these proposals.
Eugene, you have anything to add?
No.
Okay, we have time for one more question, quickly. Anyone? Any last words from the panel? Well, we only have 3 more. Oh, wait, last minute question.
Yeah, I wonder if the panelists have any. Thank you. Do the panelists have a wish list for changes to Section 230 or any changes, any specific change that you would like to see if you could draft it or redraft it?
I would strike FOSTA. I mean, Kate's right. You know, people have been arguing for almost 10 years that based on the kind of theoretical case for over-moderation, but now we have an actual test case in the form of a change to the immunity. And as Kate said, there's lots of speech that I think it would be safe to say even Congress did not intend for there to be immunity that's being taken down by the distributors because of the risk of liability under the law.
I would say, I'm not sure, maybe could be persuaded that the harms outweigh the benefits, but I would say conditionally, if you want to do something about revenge porn, I mean, not just something, if you want to do a good deal about revenge porn, then I just don't see how that could effectively be done without some liability for intermediaries. Maybe you could sort of threaten with criminal punishment the person who originally distributes it. Maybe that will deter it in some measure, but you know, there are a lot of people who are hard to deter. But once they distribute it, if you want it taken down from Pornhub, actually I'm not sure how much Pornhub say has of this, but I believe there are sites that actually deliberately do this, that deliberately specialize in that. How are you going to go after them if they have Section 230 immunity? So either, one possibility is there be a federal revenge porn statute that covers them, but that's essentially removing Section 230 immunity, just not by modifying Section 230, but by coming up with a new statute that says notwithstanding Section 230. But in any event, I just don't. Conversely, if you think Section 230 should not be amended this way, for perfectly plausible reasons, you've got to just acknowledge that there's not going to be much of a solution to the revenge porn issue.
Okay, we have 1 minute if you have anything to add.
I'm gonna agree with both Enrique in getting rid of FOSTA and with a little bit with Eugene on non-consensual intimate images.
Yeah, better term than revenge porn. I was using the shorthand. Non-consensual is really important here.
Right, it's just more accurate
Yeah,
because
exactly,
it's not,
exactly.
the only reason for using it isn't just revenge anymore. Now there are many reasons.
Exactly.
I think that definitionally, we have a bit of a difficult time with non-consensual intimate images. So, it would be a debate, but I could imagine a circumstance in which a known non-consensual intimate image, it's not like we're creating a bunch of new ones, but there's this thing that we know about in the world that is, an invasion of privacy and out there non-consensually of someone who does not want it out there and didn't mean for it to be shared in this way, and it's causing them harm. I could see there being like a notice and takedown sort of system for that, where it's like, this is the image, take it down everywhere, and you use the hash technology that we have to sort of prevent that from being somewhere on the internet. I think as long as you get your definitions right and your public interest exceptions broad enough, that could be pretty reasonable.
I think we have 3 votes for that.
Okay, well, I misread the time somehow. We do have time for one more question if there is one. And if not, we will be reconvening at 4:15 for our concluding plenary session featuring our honored guest Nadine Strassen, who will be interviewed by Debbie Gotti, director of our VFL project. Is there one last question, or should we break? Going once, going twice? All right, break.